Thank you. My name is John Russell. I'm a commercial barrister at Quadrant Chambers and I specialise in shipping and international trade disputes. The QBiT talk that I'm giving tonight is called What is Demurrage? Now, demurrage is a feature of voyage charters. Demurrage is liquidated damages for breach of the charterer's obligation to load and discharge the cargo in the time stipulated by the charter party. A voyage charter party will set out a number of hours or days in which the charterer must load or discharge the cargo. That can be a set period for loading and a set period for discharging, or it can be a single period to cover both. And that period of time is usually referred to as lay time. Now, the lay time clock starts running usually before cargo operations themselves. When the vessel arrives at port, typically the master tenders a document called a notice of readiness, saying that the vessel is ready to load or discharge, as the case may be, and the vessel is at the charterer's disposal. Lay time will then generally run a number of hours after the notice of readiness has been tendered. It's often 6 hours, but each charter party will contain its own precise terms that need to be carefully considered. Once the lay time clock has been triggered, the charterer is then under an obligation to load or discharge the cargo within the lay time that's provided for in the contract. If the charterer fails to load or discharge within that lay time, then unless a relative exception to lay time applies, he will be in breach. Now, if there was no demurrage provision, the owner would, in every case, have to prove their actual loss that was caused by that breach. And it's such a common occurrence that cargo operations take longer than the lay time that is allowed. This would lead to a huge number of disputes as to the proper amount of damages in each and every case. Typically, commercial parties want a quick answer, and they want the certainty of knowing in advance what was going to be paid in the event of delay. And therefore, almost universally nowadays, a demurrage clause is agreed in voyage charter parties, providing for liquidated damages, usually to be assessed by reference to a daily rate. So that's the simple answer to the question, what is demurrage? It's liquidated damages for delay. Another amount of damages, in this case, in the event of delay. However, if you carry out a keyword search for demurrage in any legal database, the number of hits that you get being returned will tell you that demurrage clauses, in fact, lead to a huge volume of litigation and a huge number of cases, both in arbitration and litigation. There are long chapters in all the general shipping textbooks dealing with demurrage, and in fact there are 2 specialist major textbooks dealing just with the subjects of lay time and demurrage. So why is demurrage a failure in terms of avoiding litigation? Well, I think the answer is that a third answer to the question, what is demurrage, is that it is a trap for the unwary. And there are at least 3 key traps or problems that we need to consider. First, demurrage time bar provisions. Secondly, demurrage documentation provisions. And then thirdly, the effect of exceptions. So we look at those in turn. Time bar. Most demurrage clauses include a contractual time bar. Often it'll be very short. It might be as little as a few weeks after the completion of the voyage. So it's crucial, if you're instructed by owners to make a demurrage claim, to check the clause for the time bar provision, lest you fail to make the claim in time. Now, the purpose of time bar provisions in demurrage clauses is to enable the parties to have a final accounting between them as swiftly as possible, and if any factual inquiries have to be made, to ensure that those factual inquiries can be made while minds and memories are reasonably fresh. Secondly, we have documentation clauses. And this is a type of clause that supplements the time bar provision. Generally speaking, a demurrage clause will provide not only that the claim has to be made within a particular period of time, but also that it has to be fully evidenced or supported by all the relevant documentation within that time period as well. And again, these clauses are strictly construed. How strictly are they construed? Well, very strictly is the answer. I'll give you an example. A case called the Eagle Valencia. In that case, the vessel tendered a notice of readiness on the 15th of January. Now, the owners were concerned that they might have tendered their notice of readiness too early. So, out of an abundance of caution, they served or tendered a second notice of readiness on the 16th of January. When they came to make the claim for demurrage, they only included in the package of documents that they sent to the charterers the notice of readiness dated the 15th of January. Now, the court held that the 15th of January notice had been tendered too early and was invalid, but that the 16th of January notice of readiness was absolutely fine. But the claim still failed because the 16th of January piece of paper hadn't been included in the package of documents that was sent within the time bar period. So that gives you an idea of just how strictly both the time bar provision and the documents provision are construed, and how careful you have to be to make sure that there is compliance with those clauses. The third area that needs to be considered is exceptions. I've mentioned exceptions earlier in the context of lay time. The problem here is that there is a doctrine of English law that once a vessel is on demurrage, it's always on demurrage. Well, what does that mean? Well, it's really a general rule of construction that exceptions cease to apply once lay time expires and a vessel is on demurrage. But it is only a rule of construction. And that means that if the words of the relevant clause are clear enough, then the exception may apply even once demurrage has started to run. And of course that means that there is no end of scope for arguments as to whether the words are sufficiently clear as to apply the exception to demurrage once demurrage has started to run. So I've given you three answers already to the question, what is demurrage? I'm going to give you a fourth. And the fourth answer is that it is a source of ongoing and continuing controversy. The controversy is as to what loss and damage is liquidated by a demurrage provision. In particular, is it all loss caused by the breach of the obligation to load or discharge the cargo within the lay time, or is it only the loss caused by the loss of use of the vessel during the period of delay? In other words, the inability to gain further employment and earn freight or hire. Is demurrage different from other liquidated damages clauses? That controversy has now been laid to rest by the decision in the Eternal Bliss case, and the answer is demurrage is not different from any other liquidated damages provision. The demurrage clause liquidates all damages flowing from the breach of the obligation to discharge the cargo within the lay time allowed. Thank you very much.